Erin, I don't want to make you nervous or anything, but I'm seeing the biggest turnout we've had on one of these calls. It must be that NCAComp name.
Well, thank you, Lindsay. I really appreciate you not wanting to make me nervous. You know, it's funny, it's just a webinar. I'm just in my office by myself, but it's still, I'm still going to drink a gallon of water in the first 5 minutes, so you'll all have to excuse me.
This one was heavily forwarded for it was a more widespread invite, so I'm glad to see people taking advantage of it.
Yeah, I hope it's useful. I told you earlier, this is something that we'd like to be more proactive at NCA in getting this kind of training out on our website, because I think it's something that a lot of people can use, but it's hard to kind of do the training all the time for the people who need it.
Yeah, especially right now with the limited in-person meetings, of course.
I get a lot of clients who call me and they say, I started work on Monday, and on Tuesday, my boss came to me and said, I'm in charge of workers' comp, and I have no idea what that means. So those clients have already been subjected to this presentation.
We'll give everybody another minute and then we'll get going here.
I heard an interesting joke the other day about public speaking, and I think it may have been from somebody who might be on this call. But somebody said that the most common fear is public speaking, and the second most common fear is death, which means at a funeral, more people would rather be in the casket than giving the eulogy. Thought that was a good one.
That's interesting.
I think that was a Sean Mackey original.
All right, 2 o'clock on the dot. So out of respect for everybody's time, we'll go ahead and get started, even though I'm sure we'll have some stragglers join us. So I'm Lindsay Burgess. I'm the president of NYSASIC. So thank you all for joining us today. I know this was a widely distributed invitation, so I'm glad to see so many participants on the call. Just mentioning to Erin that it's the best list of participants we've had so far on one of our webinars. So thank you all for joining. So a couple of housekeeping items, but then I'll let Erin take right over. You're all muted. If you didn't mute yourself, you may have been muted upon arrival by our mute police, Nicole, at One Group, who's awesome in helping us administer these webinars. Thank you, Nicole. Thank you, One Group. And so if you need to speak, if you want to ask a question during the or at the end, just make sure you unmute yourself. If you're talking and it seems like we're ignoring you, it's because you might still be muted. So just keep an eye on that. Alternatively, probably a better way to get questions in is through the chat box. If you'll see on your screen, there's a little like a little chat bubble you can click on for those of you who aren't familiar with WebEx. But either way, make sure you get it out there one way or another. And we'll keep an eye on the chat box, Erin and I, and respond to questions as they come, or hold them until we get to appropriate slide or till the end, but we'll make sure we cover everybody's questions along the way here. So without further ado, I thank you all for joining us, and I'll turn it over to Erin Jordan, who is the CEO of NCAComp, and she is going to give us a 101 level overview of workers' comp and kind of the bare bones things you need to know as you deal with workers' comp claims. So I'll try to steal your thunder there, Erin. I'll turn it right over to you. Thank you. Thank you for putting the presentation again.
Yep. Thank you, Lindsay, for having me today. And yeah, I hope this is something that's useful to a lot of people. Like I said, there's a lot of times that people come to me and they say, I started on Monday and now it's Wednesday and I'm in charge of workers' comp and I don't know where to start. So this is meant to be kind of a high level overview of where your attention needs to go, what you need to be looking for, what forms you'll be responsible for. And like Lindsay said, I do prefer the chat box. I'm pretty good with the chat, so I'll be watching that the whole time. If I don't answer your question immediately, I promise I will get to it soon. I might be waiting until another slide, but I will see them, I promise. So today, and Lindsay, I think you'll be sending this out afterwards, right? Do you do that as a follow-up?
Yeah, so we'll send out the recording as soon as it's available. And the slides, if you're okay sharing them, I'll send them as well.
Yep. Yeah, these slides, a lot of them have the forms that I'm going to talk about embedded in the slide. So if it's useful for you later, you can use it as a reference. There we go. So as an introduction, I'm the CEO at NCAComp. We are a third-party administrator working on workers' comp claims. And I'm reading over here, so I'm sorry about that. We have a lot of clients who are schools, consortiums, municipalities, private companies, and some insurance companies as well. I drink a lot of water while I get started, so I'm sorry, you guys are going to have to roll with that. So we do have a lot of county clients. We do work with a lot of different types of municipalities. I know that a lot of representatives at counties are working with third-party administrators and are self-insured. So today I'm going to use the words TPA, that's your third-party administrator who does your claims, but you might be working with somebody at the county office who administers the plan. You might even have an insurance company, and everything that I'm talking about, the principles are all the same across all those relationships, but I'm mostly going to be talking about your TPA. I use the word carrier throughout to mean the same thing. TPA, carrier, all I mean is that the person who is taking the forms in and who you're reporting these claims to, who you're responsible for sending the information to. Today, we're going to run through the claim timelines and the basic timeline of a claim. Like I said, this is a 101 level, so I'm not going to go too in depth. I'm going to try to stay at like a 30,000 foot view and cover the basics. So those of you who know a lot more than I do, just know that I'm skimming on purpose. And also, I'm going to try to make sure I'm defining terms, because in workers' comp, we tend to get lost in acronyms. So I try to spell out everything in here. So again, everybody has a chance to follow through from a rational standpoint if you don't have that experience. So first of all, we're going to start on the initial injury. When an employee is injured on the job, the injured worker should first notify his or her supervisor of the accident. Just move this over a little bit. If you're not sure how this works within your county, then it's important to know whether people are reporting to you, whether it's your responsibility to get that report from the individual person who gets injured or the supervisors, but you need to kind of understand the chain of reporting throughout your organization to understand where you fit in. Wendy asked if we're going to get a copy of the PowerPoint presentation, and yes, this will be sent out afterwards. And if you don't get it for whatever reason, then my email is at the end of the presentation, so you can email me after. So understand where you are within the organization and in terms of the reporting chain. Sometimes the people that I'm working with, the supervisors are coming to them. Sometimes we're working with school nurses who are going to take the initial report. But it's important that you have certain procedures within your organization. Usually the injured worker knows that they're notifying their supervisor of the accident. The number one, this seems basic, but it's actually not. There's often a mistake how this works. The injured worker should obtain necessary medical treatment. A lot of people, when they get hurt and they know it's workers' comp, they're worried that they can't go to the doctor until they have a claim number or until they've reported the claim. But, and a lot of people too, a lot of clients will come to me and say, this doctor won't treat this injured worker because they don't have a claim number. Legally speaking, they do not have to have a claim number to treat an accident. The claim number is not going to assure that a medical treatment is paid or denied. It really just identifies the claimant, the injured worker, by a number. So first of all, that's not necessary. So you can either try to tell the doctor or try to explain to the injured worker that they don't need a claim number. But the most important thing is that they're getting the medical treatment that they need quickly. You don't want to postpone medical treatment because of paperwork. When you find out, I'm assuming that you are the people who are filling out the claims forms that are then being reported to your carrier or your TPA. When you find out about this injury, make sure that you are getting a detailed account of what occurred. This assumes that you're talking to the injured worker, but if you're not, if you're getting this report from a supervisor or somebody else, make sure that they are then asking open-ended questions and report back to the appropriate office for the claim to be filed with your carrier. This means if you saw the accident happen and you saw somebody slip, don't say, I saw you slip. Does your hip hurt? Is that what hurts? Should we put in a claim for that? Don't lead them. Let them tell you what happened and write down what they say. It seems simple, but it's really hard for me, so I'm sure many of us, to not volunteer information that you can then put on the form. Provide information to the employee about their claim. A lot of people, especially if they're seriously injured, they're a little nervous about workers' comp because most of us have not put in a workers' comp claim, don't know anything about it. So make sure to have kind of a stack of reference material with you that you can assist that employee with, or make sure that somebody at your TPA or your carrier has that for them. And you're going to have that by the end of this presentation too. Consider the cause of the injury from a safety standpoint. And this is something that I think often gets lost in the weeds, but are there ways to prevent this injury from happening again? It can be as simple as, I know in this organization a few years back, there was somebody giving an example of a carpet being flipped up and the corner of the carpet being flipped up and everybody walking by and nobody fixing the carpet. If somebody trips and gets hurt on that, fix the carpet. If somebody's tripping over a broken tile, we had a claim like that, and a week after the claim had happened, the tile hadn't been fixed. So just make sure that you're looking at how the claim happened and just ask the question, has that unsafe condition been corrected? It's a really easy, really free way to lower your workers' comp costs and make the program work a little bit better. Okay. Now here's some of the legal stuff. A claim must be reported to the Workers' Compensation Board or the WCB within 10 days of the notice of the injury, and that's not necessarily notice to you. That's notice to a supervisor or somebody who's in a position of authority at the employer. Within 10 days of the notice of injury or occupational disease, or within 18 days of the event, whichever day is later. That can get pretty complicated to remember. So I wouldn't bother trying to remember that or write that down. I think the takeaway here is just to get the information over to the TPA or the carrier as quickly as you can, because there are strict time deadlines that we're working under. I tell my clients at least within a week, you have to get that in. Late reports to the comp board result in fines to the district or to the municipality, and it may delay benefits to the injured worker. And when this happens, you will be fined. You will be fined by the Workers' Compensation Board. The way that they're taking in this information now, they're taking it in electronically. So it's very easy for them to run a metric to say, okay, 18 and 10, we've got this built into our system, and this claim was reported late, boom, automatic $50 filing penalty. And then once they look at it more closely, if an injured worker was delayed benefits because of that, then the penalties get quite a bit steeper. So it's really important from a cost perspective and from the perspective of getting on top of this claim as quickly as possible to get this information over to your carrier so that they can then report to the Workers' Comp Board. It's also worth noting, I think I say this later in the presentation, but I'm going to say it now too. A lot of people tell me I couldn't fill out my form because the injured worker didn't fill out their form yet. And that is not an excuse that the comp board will accept. So if you know that an injury happened, or if a supervisor knows that an injury happened, then they are obligated to report that. The claimant, so you have that 18 and 10 rule or the 1 week deadline. The claimant or the injured worker, they actually have 30 days to fill out their form. So it's a lot more generous for the employee to fill out their form, let alone if it was a serious accident and that injured employee is, say, unconscious. They're obviously not required to be filling out that paperwork when they are not able to. So just do your best, get the information you can over to the carrier. If it's not complete, or if you're guessing, then we can always correct it later. So the form that I have put up in here is the first aid report that NCAComp has on our website for our clients to use, but it really doesn't matter what form you use. A lot of people will have an internal form that your safety department or that your administrators like you to use. It's just a first aid report. This is how we gather information. This is a really good way to start the ball rolling on getting these forms reported to the workers' comp board. And just a note when you're filling these forms out, report facts only and not opinions. I know when we get into workers' comp and we get into employee benefits, a lot of us have some very strong opinions, but the official forms to the comp board are not the place to put those opinions. So make sure that you are only putting your facts down. If the injured worker has further questions, they can be directed to speak to the adjuster who's assigned to their case at the carrier. Hopefully, as soon as you're reporting this to your TPA, either you have a contact that you work with over there, or they have a good customer service organization that they can then take over that conversation with the injured worker to help them move their claim forward. Again, people always ask me, how do I know this? How do I know that? And I always tell them the best way to figure this out is just to send the injured worker over to the adjuster, because the adjuster is the person who's doing the work, who's going to impact the claim, and it's a good idea for them to have that relationship with the adjuster if possible. Again, I harp on safety because that's, the best claim is the claim that doesn't happen. So if we can prevent another claim that prevent a claim from happening again, or the same thing happening twice to two people, this is the time. Take advantage of what you have. So if you guys have a safety program or a committee that reviews accidents, make sure to work with your TPA. And later on in this presentation, I'm going to talk about some loss run reporting to try to demystify that a little bit. And your TPA or your carrier has that information, so it's a great idea to look at that and see if we can learn anything from it to prevent these accidents from happening again. Let's see, work within your resources to prevent injuries. I have a lot of people tell me that they don't have money for a safety program. That's fine. You don't need money. You just need Google and a little bit of effort. You've got, there's root cause analysis methodologies. There's toolbox talks that are out there that are free on the internet, safety reviews. There's a lot of free stuff that you can do to try to put a safety program in place. So if you're able to, or if you're able to encourage your departments to, then I'm sure your workers' comp provider is going to be on board with that. Also a note, my coworker who helped me out with this presentation put this emoji throughout, and I said, is that supposed to be me? Because I am definitely not that gray, and it's a little insulting. So on purpose, I did not wear my hair that way so nobody would be confused. Okay, next. The adjuster assigned to your claim should be completing their own investigation on their end as well to determine the compensability of the claim. Compensability means whether or not we're going to accept the claim and pay the benefits. So types of investigations, they want to gather as much information as they can. They're going to look at what body parts should be included, or if the claim should be denied for certain body parts, or if it should be denied in full. And to do that, they should be working with you to gather as much information as they can. They're going to need the injured worker contact information so they can reach out and ask some more questions about how the accident happened. If it's a serious claim, they're probably going to need the medical provider information, and it's always helpful to have a contact phone number for any witnesses so that we can verify the story or the details. If for us, at least at NCAComp, sometimes we'll send out a professional investigator to perform an on-site investigation and gather photographs and signed statements for those involved in the claim. That it's not cheap, so it's something that we do when it's a serious injury, when there's either some big red flags, or if it's a big car accident anytime there's a fatality, that's automatically going to happen. Anytime people are going to the ICU, that's automatically going to happen. So in the case of a serious accident, don't be surprised if there's a private investigator out there gathering information, because a lot of times with really serious claims, there's a lot of information to be gathered, and we're going to use all the resources we can to make sure we get our arms around what's really going on and make sure to expedite benefits to that injured worker. This is where my coworker likes me to give the example of little things that that might trip an adjuster to look more closely at a claim. And this is where also when the adjuster is doing their investigation, I encourage you, I told you earlier not to put your opinions on the form, but I encourage you to give your opinions to your adjuster and try to build that relationship with the adjuster assigned to your account, because oftentimes you on the ground, you know the claimants better, you know the employees better, and you can give us an idea of whether or not we need to look at a claim more closely. We had one example, we had one tip where we had a client who reported a claim to us, and they said, look, this person was helping out on a bus. They were to aid on a bus, and the bus stopped quickly and the aide fell and they broke their tooth out. And they came and told me about it right after it happened. And the guy even had his tooth in his pocket, and it was just a little weird. Like, I don't know, I would think there'd be a little blood. It felt weird to me. So that kind of tipped off our adjuster to ask a few more questions than maybe she would have if this was just going through on a normal basis. And she was able to talk to the medical provider, and she found out that this person had gone to the doctor the day before to get treatment for their tooth that got chipped when they were playing baseball on the weekend. So that claim was fraudulent, and we ended up denying it because the adjuster worked with the employer and had a good relationship with the employer to have those feelings communicated to them, ask a few more questions, do a little bit more digging, and make sure that those claims that are not legitimate are blocked out at the intake. So if you don't know who your assigned adjuster is, I just encourage you to try to get some contacts at your TPA or at your carrier that you can talk to when something just doesn't feel right, or if you have questions about how things are going. So now we're going to talk about some forms, which gets a little intimidating for people when they're new at it. So the Workers' Compensation Board requires the employer to file forms related to the claim within strict time deadlines, which I already told you about. The employee and claimant will also be required to file forms in order to be eligible for benefits. So even if somebody comes to you and asks you to fill out your paperwork and you do everything, and then the claimant doesn't fill out their end of the forms, then the claim will not go through. But again, you are held to tighter deadlines than the claimants are, than the injured workers. So it's important that you fill out your forms quickly and timely. So here are your forms. Here are the forms that you need to know, that you need to be comfortable with. And I'm going to go through them one at a time here. The C2F is the employer's first report of work-related injury. The injured worker packet might be different for everybody. So I'm going to show you what our cover sheet looks like at NCA. And then the link in here that I'm going to show you takes you to a workers' comp board site where they have their recommended information in the injured worker packet. The injured worker packet is going to have all the information that the injured worker needs to put their claim in and to get their benefits and help them understand what's gonna happen with their medical treatment and their indemnity or their lost wage benefits moving forward. The C11 is the employer's report of an injured employee's change in status or return to work. That has to be filled out within 10 days of the injury report from the employee. Your carrier is usually going to ask you to fill that out. We're usually prompted by the Workers' Comp Board to complete that. Sometimes the adjuster is going to know that this type of injury is going to require that, so they might ask you for that up front. The same goes for the C240, which is everybody's favorite form. It's the employer statement of wage earnings preceding the date of accident. And that is where the Comp Board asks you for what the wages were paid for each of the 52 weeks before the person was injured. That one used to be a lot worse than it is today because the comp board has leapt forward with technology and they allow you to attach a payroll report where they used to make you manually fill out each of the 52 boxes. But now they're asking for that form more often. So it's very helpful that they're letting you attach the report instead of filling out the boxes. Now I'm going to go through each of these so you can see what they look like and understand a little bit more about them. And again, later when we send this out, you will have access to the links within this presentation. So the C2F, this is the initial report of injury. This is your report of injury. I would advise that you do not have the claimant fill this out themselves. I know a lot of people do, and a lot of people like to use this as the internal accident report. If you want to use it for your internal report, great, but this form is meant to be your perspective. And the reason that the injured workers get to fill out their own form, which I'm going to run through in a minute, their own form is the C3, and that gives them the opportunity to tell their side of the story without influence from the employer. So, you know, I wouldn't make them fill it out in front of you. This workers' comp system shouldn't be this way, but it often does turn into an adversarial process. So there's certain things set up in the law to, I don't know, promote the adversarial process, some might argue, but also basically to accommodate that this is the way it often turns out. So in order to keep things civil and to expedite the benefits to the injured worker, it's better if you just fill out the forms the way they're meant to be filled out. And then I'm going to go through a couple of tips too to help you get everything expedited in a best practices way. So the C2F is your form as the employer. I already told you that the claimant is not required to complete their side of the C2F. Lindsay is reminding me to not let the claimant fill out the C2F. It is really common because it's much easier to have somebody else fill out this form, but this really is your form. Once you send this into your TPA or your insurance company, they will forward this to the comp board electronically. So all the data that's being sent to the comp board now, it used to be forms and pages, and they still do keep an electronic, they call it e-case. It's an electronic case file where they keep all the forms, but this data is actually transferred to the board electronically. So they put it on these forms to make us comfortable, but the data goes back and forth electronically. We put here again the timelines, and here is where I lay out the penalty for late reporting is $50, or it can be up to $2,500 additional penalty if the claimant has been disadvantaged due to late reporting. There's even more that gets stacked on top of that if you get really late, so don't be late. If you take away anything from this, it's don't hide from the forms. You can do it. So these forms, I'm sorry, my screen is automatically zoomed out. But I'm going to zoom in a little bit more here. So this is the C2F form. This is what it looks like. This is the link that's within the presentation. Here you're putting the employee name, the insurer or the claim administrator section. If you're working with a self-insured county plan, you put the county plan information here. The employee information goes here. And then on page 2 here, I'm not going to dwell on this because, again, I kind of want to keep it at a 30,000 foot view. For my clients, reach out to me, let me know, and I will give you some training on how to do these forms, especially through our website. I know a lot of other TPAs and carriers will have electronic reporting. So ask your representative about that and ask how to do it online if you're more comfortable with that. But they all should be able to take this form if you want to print it out and write out on paper too. It's handy to have these printed out at your desk just so you know what information you have to gather. So the claim information here is about the time of injury, the date the employer had knowledge of the injury, and the date the employer had knowledge of the date of disability. Those two dates are very important in terms of penalties. The comp board is going to look at that, and they're going to use that when they determine whether or not you are going to get a penalty. We had this organization had one of the top people from the comp board come and talk to us when these forms were being rolled out through the electronic process, and people were asking about what dates to put here. And it was one of my favorite answers from a government regulator employee. He said, look, you guys are self-reporting these dates for telling us whether or not you are late to do it. So, you know, take that for what it is. And he's an attorney, the guy who said this. So that is what an attorney at the comp board said. And so take it for what it is. If it's, you know, if it's arguable that you didn't have knowledge until a later date, then I won't say either way, but I will tell you exactly what the attorney from the comp board said. You are self-reporting. Keep that in mind. They are not going to come out and audit your files in person to try to catch you in a lie. They want to expedite this. So just keep that in mind. Those dates are very important in terms of penalties, though. The estimated weekly wage, this work week stuff, this is all going to help the comp board determine how much of a benefit the injured worker gets for their weekly benefit. And again here, this detail on the employee injury, this is going to help the workers' comp board and the TPA understand how closely we need to look at this file, what kind of forms we need to ask you for this file, and yeah, whether we need to send out a private investigator to look at what happened there, or do a really in-depth follow-up if it's a major medical claim. You are filling these out as well for incidents. Incidents are claims or injuries where there's no lost time and there's no major medical treatment. There's no, you know, sometimes it's just a Band-Aid. Sometimes I've seen these for somebody who got spit on. So sometimes it's no medical treatment initially. It's somebody who fell and might have a bruise. But for these, you're filling these out as well so that your TPA or your carrier can report to Medicare and Medicaid, which is another thing that was required after 2014. So there's enhanced reporting for the federal regulators as well at Medicare and Medicaid. So if you're not sure of whether or not a claim should be reported, it probably should. And if you ask your TPA or your carrier, they legally are obligated to tell you that it should be reported. But again, you are deciding that on your own. So there's gray area there if you have a different process internally. But you are required to report incident claims to CMS, the Centers for Medicare and Medicaid Services. So we pull all that information just from the boxes that you tick off here on the form. Again, if you're guessing, that's okay. We can change it later. The nature of injury, the part of the body, the cause of injury, fill out, you know, left, right leg. If it's a leg or an arm, make sure to say which side of the body. That's shockingly important when we're deciding what medical care to approve. If what you see later doesn't match exactly what you wrote, that's because when we turn around and report to the comp board, we are using essentially a drop-down menu. We only get 50 choices for each one of these categories. So, so yeah, we might have to kind of guess. That's why I encourage our employees to report through our website, because we get a drop-down option and you can choose the one that fits best instead of us translating for you. This accident and injury description is a really great place to essentially copy what might have been on the injury report, or give us a more detailed explanation of what really happened. This is a box that you can write nice long sentences in. And then the work status, this is going to help us determine whether or not we need to anticipate paying lost wage benefits. And this is the accident location and witnesses. So where the actual accident happened, whether they were at the work site, whether they were working from home, those claims happen too, and they can be workers' comp if they happened while somebody was working. If they were moving office furniture or something, those are going to court and being found to be compensable. So understand that work from home employees can sometimes get workers' comp accidents too. You don't have to advertise that, but just know that that's how the courts are ruling. So put where the actual accident happened. This can help your safety personnel as well when they're doing follow-up. And then again, if there's any witnesses, and a good phone number to reach them at. The employer information, this is going to be the actual employer. So if you're somebody that's working at a county plan and there's a bunch of different members, this would be the actual member, the actual employer that pays that person's paycheck is the information that you put here. Make sure to put that phone number in and a contact name, because a lot of times we want to call that employer to follow up on what happened, the work status, a lot of different information that we need from the employer. And then the insured name, this will be the county plan, tax ID, If you're unsure of what to put here, work with your TPA on what to put here. Again, if you report it online, I'm obviously not familiar with how other TPAs and carriers work, but I know in our system, all of this information is able to auto load. So sometimes there's shortcuts if you report these online. And then if you're doing this by hand, you can sign it. If you are doing it on the computer, they're not holding people to signatures, so you're okay. And that's the very simple C2F form. So again, that link, if you click on the small button here, that link is within this presentation if you want to use it later. That'll take you right to the workers' comp ordinance. When somebody gets injured, you're filling out the C2F on your side, and then you are giving the injured worker an injured worker packet to give them information about the claim. You are legally obligated to give them a packet, this packet. The comp board makes you legally required to do this, but they don't trust you to do it. So they are also going to mail an injured worker packet to the injured worker. So just know that. And a lot of times the TPA will send it. So again, touch base with your TPA or your carrier to understand who is sending out this injured worker packet, because actually more recently we've been at NCA, we've been asked for proof that we submitted that. So we're actually kind of trying to crack down on making sure that we're tracking the fact that we are giving out this packet. The form that I show here on the little computer, this is what we use at NCA. This is a list of all the forms or all the notices that are in this packet. It's actually going to be changing as of July because of some new direct deposit regulations, which I will talk about at the end of the presentation. But yeah, so this packet has to be given to the claimant by the employer or by you. Know who's giving them the packet. And then best practice is to retain a signed receipt for the packet as proof of distribution. I know that that often doesn't happen. I know that that's really hard to do. If you can do that though, that's going to help you in the link within this presentation takes you to the workers' comp board site. And they call it the claimant quick start guide. So if you click on it, that will be kind of the first thing that pops up, but it's the claimant information packet. They have it in all the different languages, but this website actually too, if you're new at workers' comp, take a look at their publications at the workers' comp board. So this is through the employer information packet or the injured worker information packet. But this is a really great website too, to look at the resources that the workers' comp board has written, especially what to expect when you file a claim, what business owners must know about workers' compensation, and your responsibilities as an employer. Those are all really good, really readable resources for you. So that's in there. The next form is the C11. This is the form that you fill out every single time. Yes, every single time an employee leaves work, goes out of work because of their disability, or returns to work because of their disability. So sometimes, for example, somebody might get hurt and need to take a week or two off to recover, and then later they find out they need to have a surgery and they're going to go out again and recover. When that happens, you need to tell your TPA or your carrier that is happening. You need to confirm that they actually did go out of work because of the surgery. You need to follow up and make sure, because again, these penalties that the board is issuing are getting more and more extreme and large. So we need these forms in order to file the proper notices to the board and make sure that we protect you from these penalties. Sometimes the board will ask for this form even if the claimant has never lost time from work. So if somebody had an injury and they've been able to treat without missing any time from work, then the board might still ask for that. We know they haven't lost any time. We're asking you because the board is asking us, and it is not optional. So if your TPA is asking you for it, it's because you have to do it. I'm sorry. I'll make this a little bit bigger. So the C2F here is, or sorry, the C11 here, basically it has all that same information that you put on your first form. So if you want your C2 as a reference, you can use that same information. This is really the only place down here that you have to focus. The start of lost time, return to work date. If that's the same date because they haven't lost any time, that's fine. Employment status, whether it's changed there, and then there's a place to sign and date and put your information. Again, if you're filing this electronically, they won't hold you to the signature, so that's okay. Let's see, minimize that. Okay. Any questions on the C2F or the C11 so far? I like how quiet it is. That either means I'm doing a terrible job or I'm doing a good job, and I'm gonna hope I'm doing an okay job. This next form is the C240. This is the employer statement of wage earnings. This is everybody's favorite. Again, we don't make you fill this out for fun. We make you fill this out because we have been asked to provide it. If you are asked to provide it, you have to do it quickly. So, so please do your best to turn it around. We have a few clients who are not listening, which is why I can point them out, that only, thank you guys, that only do workers' comp forms one day of the week or once every 2 weeks. That's not going to be quick enough to satisfy your obligations here under these timelines. So please make sure to prioritize getting these C240s. If you need to work with somebody in payroll to get the C240, make sure that they know that this is urgent and these penalties are going to happen. These are the forms. I'm gonna click on it here. This is the actual form that the Workers' Comp Board uses to calculate the injured workers' wage benefits. So when you go out of work, and I also forgot to say at the beginning, I am talking today about most workers' comp. I know that we've got volunteer firefighters in this room. I know that we've got 207 claims that we're dealing with here, but those generally follow the similar reporting rules. If you're new at this, again, if you're experienced, don't correct me because I know I'm wrong, but they generally follow the same path as standard workers' comp claims. So I'm focusing on those standard workers' comp claims, but even for volunteer firefighters and ambulance workers, they're all filling out the C2F. They're all filling out similar forms. So that's why I'm focusing on these, but know that there's different nuances that your TPA can help you out with the nuance. So this C240 form, again, at the top here, we've got the injured worker information, the insurer information, employer, and then down here, this is the money spot, pun intended. This is where you can either attach the payroll information or complete it on page 2, and then I'll show you page 2, which is why you want to attach the information. And then just, answer the questions here. If you have any questions about how to fill out this form, your adjuster is going to be the one to answer those questions. But sometimes I know, a very common issue is if you've got somebody who is injured who has not been working with you for a full year before, then you're using a similar job. So if somebody started with you 2 weeks ago and they just got injured and you need to fill out this form, if they replace somebody, use that other person's wages to fill in the information here. This is the really fun 52-week injured worker payroll that you can fill out each individual box, the week ending date, the amount of days they were paid for in that week, and the gross amount paid, including overtime. If they have not been there for a year, then you're doing employee of the same class and you're using somebody else as an example, and you put that information in there. So again, really fun form for everybody here. Also on each of these forms at the Comp Board website, there are instructions for how to fill these out. So if I'm boring you to sleep right now, then you can go back and read the instructions on the form, and they are quite detailed. So you will be able to figure it out if you have to. Lots of penalties if you do it late. If claimants are paid late, if people who are out of work because of a workplace injury are paid late, they get an extra 20% of their benefits, plus $300 sometimes. The Comp Board can really do whatever they want. So just do things timely, please. On behalf of all of us TPAs out here, please timely complete the forms. Somebody asked, do we only fill out the C240 if asked? You can only fill it out if you're asked. if somebody had a serious injury and you know that they're going to be out, if they broke their arm and they can't do their job without using their arm, some of us desk jockeys can work with a broken arm, but a lot of people cannot. So if they're going to be out for 6 to 8 weeks because of a broken arm, and you know they're going to be out, you're going to have to do the C240. So you can wait until you're asked, or you can just get on the ball and do it ahead of time. I know the adjusters are always bragging about their clients who give them the C240 and the C11 with the C2F and give them all those 3 forms together. Those are their favorite clients. So if you don't, I'm really sorry to tell you that. But the adjusters love getting that C240 up front. It really helps make their job a little bit easier without having to ask you and remind you for those forms. Some additional important forms here. These are in the packet. I'm trying to watch my time. I'll make sure I'm going to speed up a little bit. These are in the packet. The C3 form is that's the form. And again, the links are all in here. The C3 form is the form that the employee fills out, very similar to the C2. The C3.3 is essentially a HIPAA form. It's a workers' comp version of a HIPAA form. Almost no doctors respect it, so they're probably going to have to fill out a HIPAA form later. Fun fact, workers' compensation does not operate under HIPAA. We have certain compliance things, we're not allowed to go sell the social security numbers on the street, but we are not required to operate under HIPAA. But doctors don't care because they are. So they will often ask you to fill out a specific HIPAA, and if the claimants don't want to do it, then a workers' comp law judge can actually make them do it. So just know that up front. Fun little side fact. The VDF1, this is a loss of wage earning capacity vocational data form. This isn't required until later in a claim usually, but if somebody is going to be out of work for a long time, then we're probably going to have to be working on vocational issues later. And it's a good idea to just get that form filled out up front. It asks them a lot about their job qualifications. And often people are more willing to give you information at the beginning of their claim than they are after they've been sitting at home for a year with an attorney. I've been talking a lot about penalties because they've been important lately. I'm not going to go through each of these. Basically, if you are late in getting these forms to us, then there will be a penalty. I tell a lot of clients, I have basically a Word document, a memo of this, and I say, give this to your problem people in your workspace. If people are not giving you reports timely, then go ahead and print this out and stick it up on your desk, put it in everybody's mailbox. Make sure everybody knows that if they're not helping you get these forms in timely, there will be financial consequences. The SROI SX one here, the second from the bottom, that's a new one. If wage replacement benefits end and a different payment picks up, we have to tell the comp board. And if we don't, the claimant gets $300. That's been a fun one lately. So make sure to get those forms in. Make sure to communicate with your TPA when there's a change in status of the claim. This is a best practice slide, employee support. When an employee is out of work for more than 6 months, they have a less than 50% chance of ever returning to any work in any capacity. So it's a good idea to do your best, within the labor laws, within your union contracts. But if coworkers, supervisors want to reach out and say, hey, how are you feeling? How's everything going? If you just kind of show that you care a little bit, I know that people who've been doing workers' comp for decades often roll their eyes and groan at this one, but it does help. Studies have shown that, just be a human and reach out, make sure they're doing okay. If they're getting frustrated with the process, do what you can to help them, put them in touch with us at the TPA, make sure to help through the process because it is very complicated and it can be very overwhelming, especially if people are dealing with an injury. So just reach out and tell them you care. Communication with the adjuster. I've been talking about it a lot throughout here. You're the eyes on the ground. You're the one who's local, who is in the same general area as the claimant. Somebody asked, would you suggest a C11 be filled out for everyone? Yeah, if they're going to lose time if they're going to go out of work for their injury, definitely. If it's a serious medical claim, or even if it's a minor medical claim, it does not hurt. So yeah, best practices, make your life easy. Go ahead and fill out the C11 for everybody. Okay, if there's any indication of foul play, if something doesn't feel right, if any other side information that can be helpful for us. If a claimant is causing trouble from an HR standpoint, that's good for us to know because we might make different decisions on how to handle that claim. If a claimant retires for any reason, whether it's because of their workplace injury or because of a scheduled retirement is something to tell us about quickly, please. And any other significant HR developments. I've had people that, you know, so-and-so is complaining on social media about us as an employer and the workers' comp process. Those are good things for us to know about. So just go ahead and tell everybody, tell your TPA about it. Don't tell everybody. You don't have to tell everybody. Just tell your adjuster at the TPA. Do your best to have a good relationship with that person because they are going to be able to help you. Return to work or not. Original duties. An injured worker should only return to their original job when they've been cleared by a medical professional to do so. We don't want anybody re-injuring themselves when they get back to work. A lot of times, I know union contracts can be strict. I know that municipalities have difficult return to work conditions. So if there is modified or light duty, if you can get them back, awesome. Again, keep that connection to the workplace, keep them used to coming in, even if it's sorting paper clips. But there are situations where we might not want people back. Again, if they're the HR problem, then we're not going to push them to come back. If they have a certain type of injury that's going to result in a certain type of permanency, we might not want them back. So having the conversation about whether somebody is ready to return to work or whether they should return to work is very complicated. It is beyond the scope of this presentation. So just make sure that you're talking to your TPA or your carrier about whether this should happen. It's usually going to involve some input from your HR offices as well. Claim closure. Everybody always wants to know when a workers' comp claim is going to close. The workers' comp system in New York is very generous for claimants. So oftentimes these claims can stay open forever. So the ways that claims close is in 6 different ways that I've laid out here. Either the claimant ceases treating, they stop treating and they don't pursue any other awards, then we'll go ahead and we'll close that claim. It can be reopened. The schedule loss of use or an SLU award, that's an award for a future loss of use or anticipated future lost wages because of an injury to an extremity. We're talking about arms, legs, hands, feet, fingers, toes. That's an SLU award that they get paid up front once they've gotten to maximum medical improvement. And sometimes once people get that nice big SLU award up front, all of a sudden they decide to stop going to the doctor. So if they do that, then we can go ahead and close that claim as well. There also might be a voluntary removal from the labor market ruling that has been upheld and the claimant ceases treating. If those things happen, if we're going to stop paying lost wages and then we're going to stop paying medical, then we can go ahead and close that claim as well. I'll finish these and then get to that question. The next 3, if there's a section 114A, that's everybody's favorite section, that's the fraud one. If 114A has been applied and the claim has been disallowed for fraud, then sometimes we will close the claim. But it's important to note, everybody loves fraud, but when you get a claim ruled fraudulent, that only ends the indemnity benefits or the lost wage benefits. The claimant is still entitled to their medical benefits. Even if it was found that they were a big fat liar and this claim didn't happen, we still have to pay the medical on that claim. So 114A fraud is really fun, but it's also sometimes not always the best way to resolve a claim. Sometimes if we really have a slam dunk fraud case, instead what we'll try to do is basically help out the claimant, make their lives a little less stressful, and help our clients by closing a claim with a Section 32 settlement. That is one of the 2 ways that a claim can be closed truly and forever. With the settlement, the claimant agrees to forego any future lost wage benefits or medical benefits, and they take their settlement and they close their claim. Or if they pass away, either unrelated to their claim, or if they pass away as a result of their claim, but they don't have any dependents, then we'll close that claim as well. If the person dies as a result of their workers' comp injury and they have dependents, their dependents do get benefits ongoing. So the only two ways that a claim in New York State can be closed forever is a Section 32 settlement or a claimant death. So at TPAs, we love Section 32s if you guys have the budget to do them. Okay, Kim's got a couple questions I'm going to deal with now. If a physician says light duty, does the employer have the right to refuse the employee's return to work if they cannot perform their duties? Yes. If you do not have light duty or if you cannot accommodate the work restrictions, you do not have to let them come back to work. And how long is the employer required to keep a copy of the claims if it is no longer open? If a claim is no longer open, then you get to throw out your records 18 years after the last wage replacement benefit, the last indemnity benefit was paid. So after a real quick 18 years, then you can shred everything. I think this has gotten, I don't know, better or worse now with electronic filing because it's easier to store the data. We're not taking up warehouses, but on the other hand, you know, you have all that data out there and it is a liability. So yeah, I recently helped a client because they were trying to figure out if they could close their file. And I was able to run a report of indemnity payments going back 20 years to tell them whether or not they had to keep those files. So work with your TPA on figuring out whether or not you could throw those out. It's a really fun, big project though. Tina says, how do we handle a re-injury on a previously reported workers' comp case? Is there a time frame when it is not considered a re-injury? Not really. If somebody has re-injured themselves or if they've exacerbated, that's a fun word we use a lot. If they've exacerbated an old injury, then it will be an old injury. Sometimes that's something that we'll litigate. We'll go to court to figure that out. And so that's actually a pretty complicated question. Sometimes we want it to be on that old claim, like if we've already paid out benefits. Sometimes we don't. Or for example, if they've already settled that claim and they're trying to say that they need to reopen it and we can shut it down and say, nope, that injury was for the old claim that you settled. So that is actually a very complicated question. Let's see. Beware of throwing out old files, Lindsay says. I've used files from the 70s in the past year. That does happen a lot with counties. Yeah, it's tricky. If you have to throw out old files, great, do it legally. If you don't have to, it is very handy for us to keep them, especially sometimes if we're settling a claim, we want to roll in the injured workers' old claims. So if they have had claims from the 70s, we want to make sure to include that in the settlement so that they can't then go back and reopen an old claim and that we've included all of those claims in a settlement. So it is handy to know if you don't have to throw them out. Ooh, the questions are rolling in now. Okay. How often or what is the formula for determining IMEs for the claimant? That is, again, a very complicated question that might be beyond the scope of this presentation. IMEs are independent medical exams, and this is where the TPA or the carrier hires a doctor to look over the file and give their opinion on certain issues, whether this injury could have happened in the way that the claimant said that it happened, whether a person is at maximum medical improvement, a permanency decision, like what percent of injury, what percentage the person is injured, or one of those SLUs, a schedule loss of use opinion. So an IME can be used for a lot of different things. They can be very handy. Keep in mind before you ask for an IME, again, they cost quite a bit of money depending on the specialty and depending on the quality of the IME. Some doctors give a really great, complete report, and some doctors give the minimal report, and those guys will be really cheap, but often we can't really use that in court. So there's not really a tried and true formula. There's a lot of shades in gray in workers' comp, and this is one of those areas. If somebody was injured and is no longer employed due to civil service and they are working somewhere else, do we report that? Yes, the claimant. So it's not, once the claimant has ended their relationship, their employment relationship with you, it's not necessarily up to you to know about their current employment, but it is up to the claimant, the injured worker, to tell us about their other job and what they are making, and report their job duties. So usually at that point, it's up to the adjuster at the TPA to be in contact with the injured worker to understand what other vocational issues are at play. So that usually has to involve the TPA and the injured worker. So you don't have to do that. Congratulations. I'm going to get into my last couple things here. I have just a couple minutes left and I want to squeeze it all in. Understanding loss runs, this can be a little intimidating for people who have never looked at them before. If a carrier offers you loss runs, that's a report of all of your, well, there's different, parameters, but it's a report of your workers' comp claims under your entity, whether that's the full county plan or a specific town or village. So if you are somebody who might be getting loss runs, requesting loss runs, this will give you detail on how many and what types of claims are open and receiving benefits, financial information on a claim. These next three are really good definitions. Paid, that means what we've paid out so far on a claim. Reserves is how much we anticipate to be paid over the life of a claim. This is an educated guess. This is what we are licensed to do as professionals, but if I'm being real with you, it's an educated guess based on our experience, based on a few internal resources that we have, based on life tables, CDC or Department of Health life tables. There's a lot of different calculations that go into reserves, but that is something that we expect to be paid over the life of the claim. And then the total incurred, that just means paid plus reserves. So that's what we have paid, and what we expect to pay is the total incurred. These costs are generally on the loss runs. They're siloed into the year that the accident happened. So if you're looking at a standard loss run, all of the costs, if we're looking at an injury from 2005, all of the costs will be listed under 2005, even if we're still paying checks on those claims today. Also, loss runs are often, they have a breakdown of claims by member or employer, so you can see the detail by member. I have an example here. These are the NCAComp loss runs. Again, I'm sorry if it's small, but this is our test website, or test access. So we have a lot of singers in this access. So this is a made-up company, Chicago Wood Preservation, and we have a lot of made-up claimants that also happen to have famous names. But here we have the person's name, the job classification, so that's usually their job type. We've got their age, maybe their tenure, how long they were at the employer when they got injured. The claim number is going to be on there, usually the status of the claim, how it's classified. Again, indemnity means lost wage benefits, so that usually means a lost time claim. Medical only usually means no lost time. You might see incidents on there, or report only I've seen. We've got the injury cause, type, and body part, so a brief description of what happened, and the date of accident, the date that the claim opened, which is often different than the date of accident. If you guys are really good and the TPAs are really good, it might be opened on the same day that the accident happened, but oftentimes they are different dates. So a lot of times, just keep in mind that the claim date and the accident date might be different. And then if it's a closed claim, you'll have a closed date there too. And again, on our loss runs, we have it siloed by compensation. Those are indemnity benefits, medical expense. I've also seen legal costs broken out, and then a total here. So we've got it all broken into different buckets. And then at the bottom, you should have a summary with your totals there as well. So every carrier, every TPA is going to be a little bit different, but the items on that loss run are usually pretty similar. Sorry, I'm going really fast here at the end. I know I just have, I'm over by a minute. I wanted to tell you all too, because I'm not sure that everybody's hearing this, but in November, they passed a law in New York State that that any indemnity payment now, we have to offer the injured workers the option to receive their indemnity payments via direct deposit. The Workers' Comp Board has been sending out some notices about this. They have come up with the regulations to comply or to work under that law, and they are coming up with direct deposit forms. So we're going to add one of those direct deposit forms into our initial claimant information packets so that they have the information and they have notice that they are entitled to direct deposit. At NCAComp, we are going to be sending out a notice to all of our claimants to let them know that this will now be an option. We have to be in compliance with this on or before July 1st of 2021. So we're getting down to the wire for the setup on this, but it's due by July 1st. So if you're not aware of this, or if you're not sure if this is being set up behind the scenes, or if you don't know if direct deposit is an option right now, then it's worth looking into it and asking the questions, because it's something that I know that I personally am spending a lot of time educating clients about. The specific requirement is that injured workers may elect to use up to 2 bank accounts as long as the deposit is over a minimum of $20. So if somebody is getting $40 a week and they want to use 2 bank accounts, they can. If they're getting 1 bulk check and they want it direct deposited, they can. So that's something that's changing as of July 1st. And that's going to be a new form in your claimant information packet. All right. This is my last slide. I made it. You made it. Congratulations if you're still awake. So if you have any other questions, let me know. If you want to email me, my email is there. My direct phone line is right below that email. So if you guys have any other questions or need anything, then please don't hesitate to reach out. I know that Lindsay said that she will be sending out a copy of the presentation. So you'll at least have this as a resource with all the links in there as well. And again, if you're in a plan that is with one of our clients, then, and you'd like further training on how to use our online platform, then please let me know. I would love to either do one-on-one training for you, or I've got some training videos that I can send your way if you're one of those people that likes to learn at midnight. So thank you guys. And Lindsay, I think I'm done.
Awesome. Thank you very much. We appreciate you going through that, and I don't even mind that you went over a few minutes. I think it was great information to share, and hopefully everybody appreciated it. I don't have any future webinars to announce right now, but we'll certainly respond to members if there's any topics that you want to hear about. Let me know. Let one of our members know or officers know, and we'll look to see what we can do to get you some information if you need it through the association. So I don't have anything else to share. Thank you again to One Group for hosting, and thank you again to Erin for putting that together for us. That was awesome. So I hope everybody has a good day, and get your snow sleds out here. Some of us will. So take care, everybody. Keep in touch if you have any questions.
Thank you, Lindsay. Thanks, guys.